State government and administration of the United States of America. State government and administration. The importance of the state in the American politics cannot be overemphasized. According to Professor Munro, the states are still the pivot around which the whole American politics system revolves. Were it not for the states, the national government could not function. A president could not be elected, nor could congressmen be chosen, for it is the states that arrange the congressional districts, prepare the voter lists, and provide the machinery of elections. In terms, too, is to be found the organized parties life of the nation, so important in actual conduct of our electoral institutions, national parties being little more than instruments for coordinating the individual state units of the same partisan allegations for nationwide election campaigns. Again, without the action of the state legislature, either by ratifying or initiating proposals, no formal amendment could be added to the federal constitution. Likewise, if the states did not exist, there could be no country, city, or town government, for all of these derive their authority and even their legal existence from state constitution and state laws. Divisions of powers between the federal government and states. As regards the distribution of powers between the federal government and states, both of them possess limited powers. The powers given to the federal government are enumerated in the Constitution. It is true that the powers of the states are original and inherent, but there are many limitations on them. They do not possess the powers which are delegated by the Constitution to the federal government. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States in order to deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction to the equal protection of the laws. The states are prohibited from negotiating treaties, waging war, impairing the obligations of contract, etc. The federal government guarantees to each state a republican form of government, and no state can change its republican form even by following the prescribed method of amendment laid down by law. States cannot impose export and import duty. They cannot tax federal instrumentalities. They cannot coin money nor issue paper currency. They cannot pass bill of attainder or ex post facto laws. Although the states cannot deprive any person of his property, yet they can regulate property or interfere with it under the clause of police power vested in the states. The police power of the state has been interpreted by the judges according to their own temperament. Judges like Marshall tried to increase the powers of the federal government, and judges like Taney stood for the rights of the states. State executive. The state executive consists of a governor, a lieutenant governor, a secretary of state, an attorney general, an auditor, a treasurer, a superintendent, etc. In some states, the governor is elected for 2 years, and in some others for 4 years. Up to 1947, the term was extended to 4 years. Provisions has been made for the impeachment of the governor by a House of Representatives before the Senate of the state. A 2/3 majority is required for a successful impeachment. In some states, provision has been made for the recall of a governor. However, only one governor, named L.J. Frazier of North Dakota, was recalled in 1921. When a governor is convicted by impeachment or dies in office or otherwise resigns, he is succeeded by the lieutenant governor in most of the states. A lieutenant governor is ordinarily chosen for the same term and by the same process as the governor, and in ordinary circumstances, his duty is to preside over the meetings of the states of the Senate. If there is no lieutenant governor is recalled by the people, his successor is chosen by the people either at the time of recall or at a special election afterwards. As regards the financial powers of the governor, it is his duty to prepare the annual budget and send the same to the legislature. As regards his military powers, they are not so many as they used to be. However, normally the governor is the commander-in-chief of the state militia and the state guard. The powers of the governor as commander-in-chief are actually exercised by an adjutant general, some other officer. The governor can appoint the officers of the militia. He can call out the militia to put down any riot or civil disorder. The governor has to perform certain duties towards the federal government. He is the recognized medium of communication between the state and the federal government. All orders of the federal government are communicated to the state through the governor. All proposals for the amendment of the federal constitution are sent to the Congress to the governor, sent by the Congress to the governor. Whenever the federal government wants help or cooperation from a state, it writes to the governor of the state. The governor has the power to pardon or reprieve any offenders who have been convicted by the courts of law within his state. These pardons may be absolute or conditional. The state legislature, excepting the state of Nebraska, which decided in 1934 to have a unicameral system, the other states in the United States of America have a bicameral system. The two houses are known as the Senate and House of Representatives. Both of them are elected by the people in order to avoid the charge of duplication. The constituencies for the Senate and the House of Representatives are arranged differently. In the case of the Senate, its members are elected by the counties, and every county, irrespective of its population, has equal representation. On the other hand, the House of Representatives is elected on a population basis. The strength of the House of Representatives is more popular house than the Senate. Like the American Senate, the state senates also have a longer term than the House of Representatives. Amendment of the state constitution. Every state has its own separate constitution, and the method of amendment varies from state to state. The amendment has to be passed first of all by the state legislature and then referred to the people for approval. The majority required for the passing of a constitutional amendment in the state legislature varies. Referendum is obligatory for a constitutional amendment. No state constitution can be amended in such a way as to conflict with the national constitution. Local government. In every state, there are a large number of local bodies which do a lot of work in their own spheres. All the local bodies derive their powers from the state government. They have their own officials to carry out their duties. the townships, the countries, the towns, the cities and school districts are the local units in the states. Many experiments have been made in the USA in the fields of local government, and the most important are commission plan and the city manager plan. Direct democracy. It is to be observed that direct legislation and recall are to be found only in the states and not at the center. The system of initiative and referendum prevails in most of states, but that of recall only in a few states. The necessity of the direct legislation has arisen on account of the fact that the people do not have faith in the honesty and integrity of the state legislatures. It is felt that the members of the legislature are either bribed or influenced in an undesirable manner. The result is that even those bills are passed which are hardly in the interest of the people. Moreover, a state legislature may not pass a law which the people want very badly. Thank you, viewers, for watching. I'm Shami.